Okay, good. So with that, I'll continue the session. I hope you are hearing some case law scenarios, and I'm hoping that you're able to get answers to your question. So let me just move forward. Complaint redressal timeline, right? So this is the generic timeline. It's a very common one. You must have seen this in some form or the other, but it's important that we cover this so that everyone is aware of the timeline. So once the sexual harassment has happened, from the last act of sexual harassment, you will have a 3-month period to receive the complaint. As I mentioned in the timeline part, you have 3-month period. So if there is a series of sexual harassments, like the person was harassed multiple times, from the last incident, you have a 3-month period. Uh, why is there a time limit? Why can't that be filed anytime? Of course, sometimes old cases will be pulled in because there is some relationship that has soured and she wants to just take revenge or whatever. That should not happen. The law is provided to prevent harassment, not something to address something that happened long back, unless the person complains within a reasonable timeline, and that's 3 months. Of course, not all situations it's possible to complain. Sometimes the victim may be in a shock and they might need more time to complain. So the IC, in its own discretion, can extend this beyond the 3-month period to a 6-month period. That is absolutely fine. IC can do that as long as they find a reason, right? Why she couldn't file, right? Beyond that period, you cannot do it. Of course, there might be questions that there was an amendment that we saw where it is extended to 1 year or without any time limit and all that. That's just the individual members' bill presented in the parliament. I don't think that would even be taken up for discussion because individual member bills usually don't really go through. The last one was in 1960, so you don't have to even discuss that. But even otherwise, there are several things in that bill which are wrong, which most of us may not agree with. Like they want to remove conciliation and all that, which is a good process as per the part of the civil procedure. So we feel that those things should continue to be there or all that, right? So this particular thing should be within 3 months. They should file. IC can extend it for another period of 3 months. From the day the complaint is received, within 7 working days, a copy of the complaint should be forwarded to the respondent. Why it is to be forwarded to the respondent? First chance should be given to the respondent to speak up, come back and tell them that this is what I feel, this is not a complaint, this is what is the reason. So you give them a chance to explain. If you don't do that, then you're not giving them a fair chance to explain their side. Before even considering any action, receive the complaint. You can have a discussion with the complainant if you want, understand the complaint, see whether it's within your jurisdiction. All of that can be done. But once you receive it, mark the date of complete receipt, and within 7 days, you must forward the complaint as is to the respondent and ask them to respond with their side, right? The respondent should reply within 10 working days. So it is important to note that the complaint should be received in writing in some form. Of course, the law mentions that you must give 3 copies and all that. With digital formats, emails, and all that, you don't have to make 3 copies. You can have your own structure in your policy. You can have a complaint management system like from eLearnPOSH, or you can have a similar system. There are several other systems that are available in the market as well. Or you can just have your own system for code of conduct or redressal mechanism, or just receive it as an email or just receive 1 copy and that could be scanned and put for the other IC members. There is a reason why they wanted 3 copies, so that you get one acknowledgement and there is a copy with the report, annual report, and one for the inquiry and all of that. So that is not required, but it must be received in writing in some form, right? Why writing? Because tomorrow the complainant should know, oh, I never filed the complaint. I don't know how you got this. That should not happen. So you receive that in writing in some form. As long as you can receive that, you can take that complaint. Within 7 days, you forward it to the respondent. And from there, give respondent 10 days time. And all of these are working days. So if you have holidays, weekends, and all that, consider that as period not considered. So you need to have 7 and 10 days, working days, for the whole process to complete. This will give the respondent's reply as well. You receive the respondent's reply, you read through it and see if it is all fine. You have the complainant's complaint as well. This should be forwarded. This should be forwarded uh, to the complainant, and the complainant has a right to choose Either she wants to go for conciliation or inquiry. These are the two redressal mechanisms, conciliation or inquiry. Based on that, you can proceed to the next step, whichever method you choose. Within a 90-day period from the time you receive the complaint, you must complete the inquiry or conciliation or whatever is a redressal process that you choose within 90 days, so that there is a timely completion of the process. And from there, within 10 days after the inquiry or conciliation, IC should submit the recommendations to the employer. And the employer has another 60 days to take action on the recommendation, right? So this is the timeline. So you must follow this timeline. That 90-day is a hard timeline because the law says shall. Because usually, if you usually read the law, if it says may, then it may be completed within 90 days. That's more flexible. But when it says shall, it's a mandatory timeline. So this shall be completed within 90 days. So in some cases, in case of uh, COVID and all that, there was some flexibility that was provided for any law, and that is an occasional thing, but generally within 90 days. And this is something that's looked at very carefully. So if there is any extension, don't cut short the complaint, still follow as much as possible, because some of the things that we say can need more time. But when you do that, make sure you are conscious of this 90-day and expedite the whole process. And we'll come to that as we go through some of the principles of natural justice discussions, right? So, as I mentioned very briefly, receive the complaint, get clarity with the complainant, see if it is within your jurisdiction. As I mentioned, the three criteria: people, place, and time. Accept the complaint or share the reasons for not accepting the complaint. In case if you don't feel that it's sexual harassment, make sure you let them know, you share that in writing with them why you're not accepting it, and document, even if it's rejection, document it, and do your best effort based on the spirit of the law. All that should be considered, and you should make sure the complaints must be in the form of writing. Explain the process as soon as you receive the complaint, that this is going to take all these steps to get to the response, get to the resolution, and it will have these inquiries. Make sure you have an NDA signed. If you're a subscriber to our platform, you'll have an NDA version as well there. Collect evidences. If you use our online tool to submit the complaint, which is also available as a part of the IC subscription, you will also be able to sign the NDA digitally there, and everything, right? Collect evidences and witnesses at the initial stage, so you kind of have that part of the collection, and address any concerns that they may have, right? So this is something that's while receiving the complaint. While sharing complaint as is, don't edit it, modify it, truncate it, all that, so that it goes to the respondent, and the respondent has 7 days, within 7 days, and respondent has 10 days to come back with their response. And all of these are working days. Inform the respondent again about confidentiality. If there's an NDA process, get it signed. Tell them that retaliation is not permitted as per the law. Tell them that they have their right. Just because the complaint is filed against you doesn't mean that you're going to be fired. They have the right to present their side. The POSH law is very clear on that, principles of natural justice. So they have the right to present their side. They have the right to cross-examine. They have to right. They have the right to present or bring witness or evidence to support them, right? So all of these are available. So now, with that, there are two options: conciliation and inquiry. We'll touch on both of these options. Before I pass it on to Maya, I'll just see if there are any questions that have come about. I know we are on time. How are we doing? I think we are kind of okay. So it's important that we answer the questions. I know some of you might feel frustrated that it's not my question and why are we doing it, but I'm sure some more people would find value in this, right? If the IC member is harassed, then will she be part of the IC? I think there is something in the case about principles of natural justice, but of course, let me answer that straight. Of course, if she's the one who's getting harassed, she can't be a judge in her own case, so she will not be part of IC. She has to recuse. Obviously, she'll file the complaint, so she'll be disqualified to be part of the IC for that case. For some other case, she can be, right? What if the respondent is not responding to IC? We'll talk about that later, and I'll cover that question about ex parte settlement and all that. What if the victim file a complaint after the employee left the organization? Uh, if it is within 3 months, and if it's related to workplace, Uh, it doesn't matter whether they are employee or not. Anyone can file a complaint, even a visitor can file a complaint, as long as the respondent is part of your organization. So it is very much within your uh, jurisdiction. An employee expresses his feelings to her female colleague through letter once. The female employee files a complaint. Okay, so this I understand where it's coming from, but if the person there is a concept of intent versus impact. So if the employee feels that it's a complaint, then you can take it. The punishment will also be based on the seriousness the IC feels. The reasonable person standard should be applied, and that's a very common principle. Whether the employees, you as an IC feels that the complaint is reasonable or not. If it is not reasonable, you can still handle the complaint, but the punishment would be a lot more lenient, just probably just a verbal warning, uh, rap on the wrist kind of a message can also be the punishment, and you can file the report that way. But if the victim feels that she was harassed, it is important that you handle the complaint, and how you punish the person can be vary based on the severity that you sense from that. If an employee is severely harassed and she goes into coma and not able to file a complaint, there is also provision in the law where someone who's a legal heir can file a complaint, or someone who's responsible for them can file a complaint. Someone with her consent can file a complaint. A lot of this, we need to really look at the specific case and how that should be handled. Someone in their legal heir can definitely file a complaint in that case. If HR finds that this is why it happened, then the HR should reach out to the family members and make sure this is taken care of. And if it is because of physical harassment, then it must not be considered as a civil case. You should look at a police complaint and take it as a criminal case as well. But if it's just through mental trauma, she went into coma, then uh, you can consider through others, and you can also go for a IPC based case as well. I think I answered the questions that are there. What if the respondent is not responding to IC? I mentioned that. I will cover that. Can external member be male or must it be female? External member can be male. There is nothing in the law that stops the external member from being male. In fact, there are cases where there's a famous Ruchika Singh Chabra versus Air France case where the external member qualification was the criteria, and there the external member was Michael Diaz, and obviously male, right? So what if the respondent is not responding to, what if the respondent leaves the organization before 3 months? You can hold back, right? If the complaint is filed, you can hold back from accepting the resignation. You can tell them that it's on withheld for the reason that there is a case, disciplinary proceeding that's happening. If you have already relieved the person, there is very limited control. There are ways you can handle this. You can go for an ex parte settlement, and there are ways you can collect the financial uh, penalty and all that through revenue office and all that. But it's a very complicated process. But if you receive the complaint before the employee leaves, even the last day of their work, you can hold back their. You should have provisions in your policy to do that as well. I recommend you do that, but otherwise, you will be able to hold back. How can I identify my district officer? Most district officers are listed in your WCD website for your state. If you have any problem, if you are part of our IC subscriber, we will find that under the IC tab under the district officer contact details. Even otherwise, eLearnPOSH is not just doing it for money. You can just write to our support team. We will identify the district officer and we'll email that. And that's not something that we charge for. So you can do that anytime. Yeah. Whether mental harassment to female employee be covered under this, as long as the connotation of sexual nature is there, it can definitely be covered under that. If it is just mental harassment where I'm just every day taunting you about your religious belief or your performance or anything like that, that is not sexual harassment. Of course, there are other harassments. You can have your discrimination policy and harassment policy and then go as per that, but it is not sexual harassment. How to prepare annual report, we'll cover that later. Can male employee be appointed as presiding officer? Definitely not, because the law clearly states that it must be female. If the complainer or complainant's case left the job, I think I've answered that. Um, If the complainant left the job, you handle it because your respondent is part of the organization. If the respondent has left the job, you can still handle it, but the control that you have will be very limited. So there is limited scope for you to handle that. You can withhold payments or final settlements and all that, so that you still have the rope to pull them back to handle that complaint or respond to that complaint. How to prepare that annual report? Use the templates that are there. You will find a lot of mention on our website where we covered this in detail, what should be part of it and all that. It's a simple document. IC should prepare the annual report, forward it to the employer for their review. The employer will forward that to the um, district officer. It's a very simple process. Um, if required, you can reach out to us and we'll see, let you know more about it. What if the respondent absconds? We will cover that as we go through on ex parte settlement. What if the male file a POSH complaint against a woman? If your policy is gender neutral, then you will handle that complaint as sexual harassment, but not under the POSH Act, but under Code of Conduct. You can still take action. You can still have similar IC kind of a structure for that also based on your policy. So the minimum criteria is handling it for women. You can handle it for any other gender based on your organization's policy, right? But at the minimum, you need to take care of women. And it's not that it's a biased law for women or anything. 99% of the sexual harassment happens against women. Maybe little lesser, some more happens about the third gender also, but mostly it's women who are affected. And so it's important that we handle that majority case first in a better way, and that's where the POSH law comes into play. And it's not biased in any way. It's rightly done that way. But of course, it would be ideal if it is a gender neutral policy. Do you mean the district collector as a district officer? Definitely not. Each organization, each state would declare who's the district officer. It could be the district collector, the magistrate, or whatever, maybe an official in the collectorate, right? You need to figure out, based on some districts, it is the collector also. So you need to figure out who's the district officer, and they will be the one who will be handling.